And welcome back to Constitution Hill, and of course celebrating 30 years of the existence of this constitutional court that is tasked, of course, with not just the protection but also the interpretation and application of our constitution so as to make it a living document for every South African. And of course we are also going to be speaking throughout the morning here, various reporters covering this event for us as well. We'll be speaking to so many people who've walked through these halls, who've sat on the benches behind me, and so looking forward to hearing their reflections 30 years on. And we spoke earlier about this building and, of course, the brickwork. And I'm standing right next to it, of course, some of the bricks that were taken from the demolished old fort jailhouse. And these are the bricks, and they, of course, are symbolic in terms of just building a new justice system and speaking to justice for the majority of South Africans, and of course also representing the people that have passed through these halls. And I'm joined right now by an organization who also have over the years made sure that South Africans do access justice through this particular court in so many instances. And I'm joined by Section 27's Sasha Stevenson. Sasha, always a pleasure speaking to you. Thank you so much for coming through this morning. A great occasion, you know, celebrating 30 years of the Constitutional Court in just entrenching South Africa's constitutional democracy. Your reflections for these 30 years?
It is a wonderful opportunity to celebrate something that I think is so important. South Africa is really fortunate to have this document that provides the foundation of our society. And of course, just having the document isn't enough. We need to work every day to make it real, to make it to make a society that the Constitution envisages and envisions. But today is an opportunity to celebrate how far we've come, and I suppose to reflect on what is still needed to make this constitutional democracy even better.
So let's talk about that, because you've had many a landmark ruling passed down in this very court, and of those, I know it's tough to say which one, you know, really stands out, but in terms of just being so significant, you know, which ones come to mind for you?
Well, I think I'll reflect on one of the earliest cases and one of the most recent. Probably one of the most important landmark decisions of this court was the Treatment Action Campaign case about access to prevention of mother-to-child transmission of HIV medication. And our partner organization, the Treatment Action Campaign, brought that case. And what it did was it kick-started the biggest ARV program in the world, a program that saves millions of lives every day, and of course a program that is at risk because of politics in America at the moment, but nonetheless an important statement about the human rights of particularly vulnerable people and the obligations of the state when it comes to realizing those rights. And then most recently, we were here not long ago in relation to the Copyright Amendment Bill, and in that case we were representing Blind SA and asking the court to read in a provision into the Copyright Bill that prevents people who are blind and visually impaired from being criminalized for converting the written material into accessible formats while the process of law change is happening, and we were successful in that application. So spanning a period, the TAC case was 2002, this case was 2024, spanning a period of 22 years, we've had a range of really important, really landmark, really fundamental decisions from this court that make people's lives better.
And that's the beauty of this court, the fact that every South African has direct access to the court. So to bring those very important constitutional matters to be decided here. But what do you believe still needs to be done? Where do you think this court can do better? And their job is, of course, to interpret and apply the Constitution as it stands. But where do you think we could do better as a nation?
The court can decide on decisions that are brought before it, on cases that are brought before it, rather. So really what is needed is for organizations like us and other organizations, individuals, and government in coming to this court to make sure that we are pushing forward the values of the Constitution. And I think that's happening to a large degree. As you say, this court is accessible to everyone. Just the fact that we have these benches indicates that people can come off the street and they can watch a constitutional court case. That's very unusual. Around the world, that doesn't happen. We have direct insight into the highest court in the land. That's really special, and it's important that we all invest in this constitutional democracy, invest in what this court and what civil society organizations and to some extent government is trying to do to realize rights and to make South Africa the place that the Constitution envisions.
I had the privilege of sitting down with the Chief Justice yesterday, and one of the criticisms that I brought up to her of the court is perhaps in when the judgments are delivered, sometimes not having time frames, attached to that, and how that could potentially become problematic down the line for the applicants. But what are your thoughts on that, particularly when one thinks of the case like the Michael Komape case and, how impactful that was as well in setting norms and standards for schools' infrastructure. But what are your thoughts on matters like that?
Well, I think that the question you raise about timeframes is very important. One of the important elements of the Michael Komape case was that there is a time-bound requirement for reporting and for implementation of the judgment. And what that does is that it allows us, representing the applicants, to monitor implementation, and it allows the court to do the same. So I think that using what we call structural or supervisory orders that allow the court to not just make a decision and hand it over, but really to have continued insight into the matter is really important. And what that also does is that it allows the applicants, the litigants, to have that continued insight, to make sure that a court order is in fact being implemented. Of course, it places quite a significant burden on the applicants as well, because in that case we have for years monitored the rollout of toilets in Limpopo, and that's a resource-intensive and difficult thing. But what it's meant is that there are only a handful of so-called priority 1 schools in Limpopo that still need toilets, and that's because of a court decision that said that it's unconstitutional and undignified for children to be using unsafe pit latrines.
And just as we celebrate 30 years of the existence of this court, just your sentiment for those who work here, serve here, and also access this facility. What's your message?
I was so privileged to work here as a law clerk in 2009 for the former Chief Justice Pius Langa, and it's always such an absolute joy to come back to this building. It's a building that's welcoming. It's a building in which you can really see what it is we're trying to do in the South African project. And so I'm grateful to the people who work here, to the people who are making justice real, and to the people who are bringing cases to this court to get clarity on the Constitution and to ensure better realization of rights for everybody.
Sasha Stevenson from Section 27, thank you so much. And of course, with that, we're going to send it back to studio for a quick break. And when we come back, I'll be sitting down with Justice Albie Sachs. He's already taken his position, so I'm going to join him.